Jackson were indicted under. And you can't tell me that we're going to rely on dicta in a Supreme Court case, because the Supreme Court specifically has already said you can't rely on our dicta, and that's Weaver versus Massachusetts at 137 Supreme Court 1899. So let's move from dicta to the reality of the test. The reality of the test is Mr. Nichols and Mr. Stillwell and anybody else in here are members of the people, just like they're members of the people for purposes of the Fourth Amendment. You know, he's been convicted of a felony, he's been convicted of a felony, but he can still say, because the right of the people to be secure in their personal papers from an unreasonable search and seizure, if the people meant felons couldn't be protected by the Fourth Amendment, the people.
Good morning, everybody. Y'all share this live stream. We just taking an inside look at the Young Thug trial.
Those provisions. So I guess
this is a motion hearing. The trial is set for November 27th.
I guess what I'm saying is, based upon the record and based upon the lack of record and proof from the state, I think that the state has not carried their burden and that these statutes are unconstitutional.
All right, thank you, sir.
Your Honor, may I just briefly say on behalf of Mr. Stillwell, we adopt all of...
This is a motion hearing where the defense gets to hear some of the evidence the prosecution plans to use at trial. If a judge finds some of this evidence inappropriate, he will make it inadmissible.
The state has presented and has resisted an evidentiary hearing in this matter. It's pretty clear that it is the state's burden to prove that the challenged regulation is upheld under the Second Amendment. And it seems to be that attorney argument is not evidence. And that's well recognized. That's why I tendered for the record specific evidence, in this case for the record. And there are citations of attorney argument is not evidence. There are a lot of citations. I'd refer Your Honor to Rigby versus Jennings, R-I-G-B-Y, J-E-N-N-I-M-G-S. It's 630 Fed Sup 3rd, 602, with string citations that attorney argument is not evidence.
Y'all share this video to y'all live stream, social medias. Share this to Facebook, Twitter, Instagram.
All right, sir, thank you.
In Your Honor, although I thought under the Harvey...
Yes, Mr. Weinstein.
...should not be necessary, Mr. Kendrick also adopts Mr. Harvey's arguments.
Unless you're opting out, I'm going to assume that the argument applies to all those similarly situated.
Thank you, Your Honor.
All right. Mr. Mihalski.
Are you prepared to rule, or do you need me to go forward?
No, go ahead. Go ahead.
Just to correct, I think what might have been a mistake. The state has never resisted an evidentiary hearing. As Your Honor is aware, the defense has repeatedly requested the appointment of an historical expert, and my recollection is that Your Honor decided that wasn't necessary, and we agree, but we haven't ourselves resisted any kind of evidentiary hearing. Mr. Harvey and all others had, every opportunity this morning to present evidence, and they could have done that, and they did. But,
yesterday, Detective Dennis testified.
I do know also that
some of these guys, these police officers, is testifying. This is a state case. So city police that's been dealing with them forever since they was young boys, that know them from their neighborhood, the guys that police their neighborhood. One of them testified yesterday as to the identity of several guys, and he mentioned that he has a fake Instagram profile where he was following one of the defendants, and one of the defendants tried to destroy evidence, but it was too late. The agent had already been following him for months.
I had a chance to read of the 56 pages. Seems to be correct, but again, it's just 131 and 133 just have to be consistent with the nation's history of firearm regulation. Now, there were a number of points made. And let's start with Mr. Harvey's brief.
Yeah, he was a gang expert. Very damaging testimony.
This is page 3. The plain text, and I'm still on the people. Okay, I'll get into the weeds if we need to, but the Second Amendment admits of no exception. That's page 3. Incorrect. What about minors? What about incarcerated individuals? What about people on planes? What about people in court? What about people in public schools? What about people in this courtroom, right? So that's just flatly incorrect. And the citation to none is very interesting to me because that was an 1846 case, and it's about concealed carry. Nowhere are felons mentioned. Nowhere in that decision. It talks about how great the Second Amendment is, and it's very, it reads like Patrick Henry. It's great, right? But it's not on point. And I understand my colleagues have a duty here to perfect the record, and they have a duty to raise what they understand to be every viable challenge, Your Honor, but this is quite a big ask of a judicial officer. To strike down these statutes today as unconstitutional, Your Honor, the state would respectfully submit that this is a little bit, and I think Your Honor is aware of this, feels like legislating from the bench. It feels improper. We're putting the cart before the horse here. Recapitulating, okay, just to recap. The Supreme Court of the United States has not passed on the constitutionality of the Georgia statutes, okay? The United States Supreme Court does not rule statutes unconstitutional by inference, by implication, by extrapolation. No, it's not how it works. There is, of course, pending, as Your Honor knows, in the Georgia Supreme Court, the question of what is the appropriate framework within which to analyze Second Amendment challenges. We're well aware of that. But notice that this is not a question.
The Georgia case is pending right now.
I guess it's Massey v. State.
And what's the citation?
I have it as S-23.
The gang expert said the war started around 2015.
But the printout here looks like it says
They've been watching them niggas ever since. If it wasn't for the violence, they probably would still be on the streets doing music and getting money.
Well, there is no citation because cert was granted. It is S24A0131. It was docketed 9/13.
Y'all like the video as y'all come
It
in.
is on the calendar for argument before the Georgia Supreme Court in January of 24. It's a different docket number than the original S-23.
What's the other underlying appellate case that Massey came from?
Well,
Meaning, was there an appellate opinion in Massey?
Yes.
Can I have that citation?
Yes, sir. It's Kuhlman, Kuhlman, Judge, and Kuhlman is 317 Georgia, 232, decided on September 6th of 23, and that was a remand to the trial court for the trial court to determine the constitutionality of a section of particularly of 131 under both the Georgia and federal constitutions.
Okay, so where does Massey come from? Is Massey another?
Massey is a standalone case on itself.
Well, did Massey have an underlying appellate opinion? And
No,
if so, what's that citation?
Judge, I don't think it is. It was on application for interlocutory appeal. So there wasn't a appellate decision. There was a decision from
Trial court?
Yes, sir.
Do you know which trial court this came out of?
The trial court that clearly got it wrong.
It's one of Young Thug defendants right there.
I don't, Judge.
Who is that? One of his co-defendants.
Which
Who is
trial
that
court
right
came
there?
out? Or which county?
I'm sorry.
Okay.
I don't.
But Your Honor, I'm looking at sort of the certified question here, which is what is the appropriate analytical framework for deciding Second Amendment claims like Massey? So it's the question that's before this court right now. There's a Second Amendment challenge. What's the analysis? Not is 131 unconstitutional or not? Not is 133 unconstitutional or not? There's a big difference. So for Mr. Harvey the fact that it's pending in the Supreme Court of Georgia gives the state a little pause on us, jumping the gun on that decision.
He said, I forget his name.
Perhaps,
I only know Gunner and
that
Thug.
we're waiting, sort of see what they say. But either way, the choice that they're between right now is between do we go ahead and do the historical analysis and dig into those weeds all the way back, into the founding era and the Reconstruction period, as was done in, a couple of the cases they cited to, or do we just say no, they're not contemplated as people that are protected by the Second Amendment and stop there? But either way, Your Honor, either way the question's answered, it's not going to be that Georgia's felon in possession statutory scheme is unconstitutional. It's just about what framework applies. And if you have had a chance to read the state's response, Your Honor, you will know that it is written with the assumption that Bruin applies in the worst way for the state. The history supplied there actually goes back to AD 602. I don't have to, but it does. And it hits hard on the sweet spots, too, Your Honor, of late 18th century Reconstruction period and the mid-19th century. Mr. Harvey and Mr. Sharp and Mr. Weinstein here, they have skin in the game on this. Of course, they're going to say this statute's unconstitutional, but no controlling authority in these United States is there. I mean, I haven't heard any that says Georgia's felon in possession statutes are unconstitutional. Mr. Harvey has argued about the Georgia militia pool, I guess, towards the end of the 18th century, beginning of the 19th century, as evidence that, Georgia allowed felons to possess firearms. But, these are not, in this case, these are not service weapons we're talking about here, are they? And that was a very exceptional period in this country's history. I mean, that was a very singular period. Formative, yes, but we are not in the 18th century at this time. We're in the present moment, and a lot of very good laws, by the way, have been passed since the antebellum South and the Civil War, et cetera. And 131 and 133 are among them. And Mr. Harvey hasn't shown otherwise. I mean, look, the United States Supreme Court hasn't said anything about Georgia's statute. The Georgia Supreme Court itself is now wrestling with the issue of what analysis to apply. I think for that reason alone, those reasons alone, that the state's respectful suggestion is that you leave these statutes as they are, Your Honor. And I will, and I'm prepared to go into the weeds about the historical analysis if that's the court's pleasure and preference. But I will refer to the state's briefing on this issue if the court is interested in looking back on that. I do think that the Georgia history of felon in possession stuff is sort of irrelevant to Bruin, because Bruin specifically says it's just got to be consistent with the nation's history of firearm regulation. It doesn't have to be, you just have to have a historical analog. It doesn't have to be a historical twin. I mean, that's specifically not required here. So if Your Honor has questions, I can go into it. But if Your Honor is satisfied again with the presentation, with your permission, I will conclude, Your Honor.
Let me ask you to pause, both of you to pause. I'm going to take a look at a couple of things. So I'm going to be in recess maybe about 15 minutes or so, so you all can stand at ease, and I'll let you know if I need more argument, okay? Yes, Mr. Steele.
Question. You still want is Christopher Massey versus State?
I got it.
Christopher.
I got it. I was able to find the brief of the appellant, so I was able to find it. Okay, all right, so we're going to recess about 15 minutes.
Thank you, Judge.
All right. Hey, Wes.
This is crazy.